Hi, I'm attorney Julie Half, and today I wanted to talk about a very important decision that was released last week by the Florida Supreme Court, where they are talking about an amendment to Rule of Civil Procedure 1.510, which is the rule on motions for summary judgment. Now, this rule would be effective May 1st, 2021, and it changes one word, but that one word has a huge impact. What they're doing is changing the standard that summary judgments will be decided under in Florida to match up with the federal standard, which a vast majority of the states already use. So what we have now, we look at, there's no genuine issue of material fact, and then the moving party is entitled to summary judgment as a matter of law. The federal rule of procedure, that's Rule 56A, says that summary judgment is required if the movement shows there is no genuine dispute as to any material fact. So we've got genuine issue versus genuine dispute, and that's the word that's being changed. Now, why did they do this? What are they looking at? Well, first they said that Florida courts have repeatedly declined to recognize the fundamental similarity between a motion for summary judgment and a motion for directed verdict. So that's one of the things they're looking to correct here. They also noted that Florida courts have required moving parties to conclusively disprove the non-movement's theory of the case in order to eliminate any issue of material fact. There's no requirement in the federal standard that the things that the moving party has to negate the opponent's claim on the federal side, but that seemed to be how sometimes it was going when this was being applied in Florida. So it's not just the moving party's burden. They want to look at who has the burden of persuasion at trial, and they want to have that standard match up. Now, third, they also said that Florida courts had adopted an expansive understanding of what constitutes a genuine or triable issue of material fact. They said the case law is not entirely uniform and cited one particular treatise that indicated that the existence of any competent evidence creates an issue of fact, whether, however, credible or incredible, substantial or trivial, stops the inquiry and precludes summary judgment as long as the slightest doubt is raised. Now, I think it's this section of this treatise quote that the Supreme Court included that they're really looking to make this change to get away from. What the federal rule instead focuses on is the evidence is such that a reasonable jury could return a verdict for the non-moving party. If the evidence is merely colorable or is not significantly probative, summary judgment may be granted. It says a party opposing summary judgment must do more than simply show that there is some metaphysical doubt as to the material fact. And the court should not adopt that version of the facts for purposes of ruling on a motion for summary judgment. So this is going to be a big deal. What they've done, the Supreme Court, is come in and invited the public, lawyers, to come in and file public comments. Anyone who might have an interest in this, they may or may not, which means they probably will, schedule oral arguments on this before it becomes effective in May. What I thought was a great summary of why they're doing this and what we're looking to. They said overall, and especially as to each of the key areas described above, the federal summary judgment standard is more rational, more fair, and more consistent with the structure and purpose of our rules of civil procedure. Now, there was a dissent that this change was taking away the sacred right of the jury, as put forth by our founding fathers, to resolve disputes between people. So that it'll be interesting to see which parts of the community come out and in favor of and against this change. But for the moment, this is the change that's been amended. There may be some additional change in the future. They're actually inviting people to comment also on what other changes to Rule 1.510 should be made other than changing that one word. If there's other parts of the federal rules language that should be incorporated as well. But this is a very significant decision. I think there's going to be a lot of discussion and commentary on it before it comes into effect, if it even does come into effect in this form, or as a result of the comments that are submitted and any further argument on it that something else judge changed. So watch this space. There'll be a lot to come on that this year. Thanks. Have a great day.